Good day, viewers, wherever you're watching OGTV live and direct. I am Obaoluwa Seunfunmi Ogunleye. I welcome you to your dialing program, Peace and Conflict Resolution. With me in the studio, I have Dr. Akintunde Samuel. Dr. Akintunde, you're welcome.
Thank you for having me. It's a pleasure.
You're welcome. And in the studio as well, next to Dr. Akintunde, have Barrister Olugbenro Ogunbade. You're welcome, Barrister Olugbenro.
Thank you for having me.
You're welcome. When we talk about employee and employer, who is an employee, who is an employer?
Well, let me start by describing employer-employer relationship. An employee relationship is based on an agreement in which a party agrees to work as a worker with another person called an employer based on certain terms of agreement.
Okay.
Now, it could be oral, it could be written, although the practice is that within 3 months of such agreement, the terms should be well stated. In clear terms, what is involved, what type of work, what are the remuneration, what are the basic conditions to guide the relationship. So that is basically employee and employer relationship. And it's pervasive because even between people who have a small scale businesses, we still have that type of relationship. So because many people will focus big companies that are multinational companies, it's not only at that level.
Okay.
Also, we have what we call contract for employment. It's also employer relationship, but it's different from the regular employee-employee relationship because that one is for specific activity, specific project. And as soon as that project is completed, the contract terminates. There are different conditions that guides each of these relationship. Those who are legal professionals, they can expatiate about the differences. But basically, one is continuous until terminated according to the agreement. Another one is one for specific project that terminates when that project itself is completed.
Oh, okay. If we are talking about the relationship between the employees and the employers now, Barrister Olugbenro, employee, employer, is the relationship between the employee and employer different from the other relationship that we have around us in the society?
Well, as well stated by the doctor, what we have essentially is because of the fact that two people are dealing with each other, there necessarily must be an agreement of sorts.
Okay.
And it's always a kind of a situation whereby it's all pervasive, as has been said. It is not only in an official relationship that it can occur, even in unofficial relationship as well, even in informal and formal as well. So in that regard, the fact that people are coming together to deal with themselves with regards to a particular kind of venture, it necessarily gives the indication that they are engaging in a contract, they are engaging in an agreement. And this one will form the basis of what the relationship between the two of them will be like. This will form the bulwark of the terms and conditions with which they engage with themselves. You are to do this, party A is to do this, party B is to do this. So in the end of the line, this is essentially what we intend to achieve with the employment relation. So in that regard, the law focuses on that relationship, and that is why it is a contract. And necessarily, at any point in time, bearing with the fact that it is a human relationship, sometimes disputes will arise. And all these things must have been aggregated into the contracts to understand that at any particular point in time that this issue comes up, then we can resolve it this way or that way. And that is what the relationship affords to anyone who gets engaged in it.
Okay, that is fantastic. Let me come to you, Dr. Akitunde. The causes and the impact of employee and the employer in relationship and disputes.
Well, let me just add to what Barrister has said in terms of the peculiarities of employer-employer relationship.
Yes.
You see, there may be a type of understanding for one to work for the other, but it's when we are talking about employer-employer relationship, it excludes communal work relationship. We can have community, association. They can let us work together to do this. Do this for me, I do that for you. No, that is not employer-employer relationship.
Okay.
It also excludes domestic relationship between husband and wife, children and their parents, what you do within domestic arrangement, except when you have a formal setup. Okay. But if it is domestic, no, it doesn't apply that way. Now, a dispute between employee and employer causes. First, like has been said, if the terms are not clear, of course.
When the terms are not clear.
You see, that one is prone to misunderstanding and eventual conflict.
Okay.
That's the first thing. If the terms are clear, the possibility of conflict is minimized.
Okay.
Because everybody knows what's supposed to do, what's not supposed to do. But beyond that,
yes,
we have a problem of managing that relationship. Because we are from different background in terms of gender, in terms of educational background, in terms of
individual
differences. So there is bound to be differences which might lead to conflict in any human setting where people are not are free to express themselves. So therefore, that's why we now need people who will be able to manage it. When you don't manage it properly, there is bound to be conflict. That's why we have a set of people called personnel manager, people who manage personnel in organization. So there are so many ways by which decisions could be managed by experts. So that's the second the causes. Then we also have causes that are external. During this period of economic hardship, there are unnecessary conflicts because people bottled themselves, a lot of problem, tension. So people just burst at times and you wonder why this. So some of them are valid, some of them are not valid. This is where expertise coming to separate the two. So that's the third reason. We also have reasons that are biological.
Also biological reasons.
Yes, biological. That's why you do a lot of screening tests before you employ people. Because a lot of people go about with different type of conditions. So before you employ, you must. That's why the labor law requires that employers should conduct tests.
Okay.
At your
medical tests.
Yes, medical tests before you employ somebody. And as a personnel manager, you must be able to match people who are coming in and people who are already in, so that they will be some people that are compatible. Because if you employ people who are not compatible, there is likely to be problem with team, working together harmoniously to achieve corporate goals. So if they are not compatible, already the seed of conflict is already sown to it. So these are the 4 ways I can talk about the possible causes. Then the impact, of course, the impact is so clear. There will be tension. There will be misunderstanding that will divert attention.
Transfer of aggression.
Transfer of aggression. Now, and there will be, you transfer efforts and resources that should be concentrated on making the organization to be effective, to get
go.
revenue, to achieve its own goal. You transfer it to resolving conflict. See, and that one will also lead to problem in the organization that will be transferred to the home, to all those other social platform that will create problem in society. So these are the possible effects, or what I can call the cost of conflict whenever they arise in organization. And the solution, are also in line with the causes.
Okay.
But the first solution, to my mind, is to realize that certain things are inevitable. Certain misunderstandings are inevitable. So the solution, therefore, is to prepare to manage it. If you have an expert, especially in an organization, personnel manager, where you have good personnel department, it will be minimized to the least possible rate of occurrence, because we have an expert who
People who manage people.
People who manage people, who can ensure that this conflict is. You see, many people believe that conflict is inevitable. I want to say that conflict is not inevitable. You see, let me give this illustration. Before, people now will say there is accident, but people say no, accidents are caused.
Yes.
Because there is always a reason. So in the same way, when there is a dispute or conflict, there is always a reason that could be anticipated. So, and when whether it's going to occur or not occur is a function of the way it is expressed and the way it is managed.
Okay.
So if you train people to express it properly, there is a system, a structure for anticipating and expressing grievance in a harmonious way, in a friendly way. And there's a system for also managing it as a routine. You see that you convert such conflict into a mutually pleasant experience that will result in better relationship, because you know each other better, you're able to relate with each other better, you're able to maximize the peculiarities, the challenges, the expertise
within the circle of employees and employer
of each person properly, so that you achieve corporate goal, team goal more effectively.
Okay. Anyway, that's fantastic, Dr. Akitunde. We'll be right back. We'll go on a very short break. Welcome back to the studio. I still have my guest here in the studio, Dr. Akintunde Samuel and Barrister Ogunbade Rotimi. We've been discussing the relationship between the employee and employer, their impact, and many things like that that will be of favor to you wherever you are in your workplace, and so many things that we're going to discuss that will be of benefit to you. Barrister Ogunbade, we cannot erase the issue of labor union, the court issues, and many things that usually come up between the industrial disputes. Let me put it that way, industrial disputes. If mediation could be of an advantage, which will save our time, save resources, than going to court, and oftentimes you realize that one party is dodging the court order to make sure they buy time and all things like that. How do you see mediation working on this issue, on the relationship between employee and employer?
Let me come into that by stating that virtually all the laws relating to industrial relations have been codified. virtually all.
Yeah.
Labor relations relates to that part of law that the essential laws, legislations, and everything that has to do with law regarding labor relations have all been put into laws. They are acts of parliament, they are laws governing labor relations. Virtually everything that we need to know that needs to be for guiding
Yes.
in aspect of labor relations are available in our laws. Only novel areas that are just coming up are those ones that I can say that they are not really being given a binding of the law. But nevertheless, in that regard, if all our law books are full of acts and laws of the legislations giving meaning to labor relations, definitely they'll have to look into the law books. And that's why essentially most of these labor relations, you see them going to court. And that has even necessitated a creation of a separate court which deals with labor relations now. I think for over like 10 or 15 years now, there have been the National Industrial Court.
Yes.
You understand? So, and that court has even churned out laws. They have churned out decisions, which are part of our laws, which they use to govern labor relations now. So you can see that in that aspect, the law is growing. If there is any new idea or new area that is being brought in by respective parties, definitely when it gets to court, it will be made simpler and made to be more reckoned with by the parties in the case. But in that regard, we will not rule out mediation as well. Because essentially, even when you get to court encourage mediation. Courts encourage people to sit down and talk within themselves. You understand? And in this area, where we have all legislations in that regard already known. So if one party is trying to not obey the law, they know the consequence. They quite know the consequence. But in most times, it will always look as if in order not to spoil the relationship. That's why sometimes they don't go the whole length of applying the full brunt of the law. At a time, the courts declared that workers should not go on strike because of this that has been on ground.
Yes.
You understand?
Yes.
But you know, we will not try to rule out human indicators in this regard as well. We as human beings,
Yes.
whatever happens, we may want to do what we want to do. You understand? But even at an extent of damning the laws, well, I may say this is an aspect in which most society grows. If you see an infraction, if you know that you are engaging in an infraction, definitely something will put you back in your mind that you shouldn't go further anymore. You understand? By the time we'll mix all these ones together, definitely people will come to the realization of the fact that whatever aspects of that thing that they are doing is still something that is governed by law. And they shouldn't go beyond what the law stipulates. So this is essentially what the court have been trying to pronounce all the while. They always want smooth working relationship between the employer and the employees. And you know, it's even an aspect of relationship whereby, like the doctor said, the dispute ought to be minimized, because this is something that one can as well get to know even before the dispute comes up. And in that regard, bringing people together, nevertheless, yes, differences, dispute do come up. But in a situation whereby these people can be nipped in the bud before they come out all in the open, it just relates back to the fact that people are sometimes not trying to obey the law or trying to circumvent the law for their own benefits. But if there is a full application of the law, there will be smooth working relationship between the employer and the employees at every point in time. At every point in time. And you see, even that is the reason why you see most of these industrial disputes, they get resolved so fast. Yes. Because it will affect the economy. it will affect even domestic relations. It will affect every space of the society, and that's why dispute in this regard has to be resolved very, very fast. And in that regard, we cannot rule out mediation as well, like I have stated. And this mediation should be one that is still within the confines of the courtrooms. Like courts are encouraging mediation as well. And that's it.
Okay. Now, let's talk about the relevance of multi-door courts in mediating issue. Are you getting it? So, what is their role?
Yeah. Multi-door courthouse is a recent initiative of government to ensure that justice gets to the grassroots in a way that is affordable and ensures that disputes are resolved expeditiously.
Okay.
Now, the problem is many people are not aware of its relevance to them and area of application. But let it be said here now,
Okay.
that it is supposed to take out any type of dispute that any person may have.
Okay.
Except, of course, where we have criminal case that is complex.
Which cannot be done.
That
will go to
that one is between the state
court
and the individual.
Yes.
There's nothing.
Yes.
But any other interpersonal, it can.
Okay.
Now, but let us go further about the relevance of a multi-door as a vehicle for employing mediation. Mediation is supposed to be one of the first options when it comes to industrial relations, but often is the last. That's one of the problems we are having.
Okay.
You see, because by the time you get to court, the case has become complex. And what you're expecting from the court is you are right, you are wrong. This is what you must do, this is what you must not do. And often, it's not always possible for the court to supervise that relationship because that relationship continues. You see? So that's why it's better to adopt that mediation.
To adopt mediation. That is yes.
Mediation.
Okay.
Because you see, industrial relation law is based on law, but not strictly legalistic. It's just like husband and wife relationship. There is a law, but the day-to-day operation cannot be based on law.
Okay.
You understand?
I quite understand that, Dr. Akitunde. Everything cannot be based on law. And that is why it is better to judge than to war.
That's right.
Thank you very much. I must thank you greatly for coming on the show today. Barrister Ogungbade, I must thank you so much. Thanks for coming.
Thank you.
Dr. Akitunde, I must thank you as well.
Okay.
Thanks for coming. This is where we'll be drawing the curtain on the show. I am Oba Seunfunmi Ogunleye. See you next time, same station, same day. Thank you.